Hello and good morning everyone. This is the AV News on Channel 17 and I'm your reporter Melina Granda. Today we're here to talk to you guys about the Reno versus American Liberty Civil Union case. This case deals with both the Fifth and the First Amendment. So before we start, I want to pose a question to you guys to keep in mind throughout this entire news broadcast. So, did certain provisions of the 1996 Communications Decency Act violate the First and Fifth Amendments by being overly broad and vague in their definitions of the types of internet communications which they criminalized? So after this broadcast, think about that question and we'll refer back to it. So this case actually deals with all 9 justices of the court voted to strike down anti-indecency provisions of the Communications Decency Act, the CDA, because they violated the First Amendment's guarantee of freedom of speech. This was the first major Supreme Court ruling on the regulation of materials distributed via the internet. Now I'm going to send you guys over to Megan to talk about the CDA and what that's actually about, so you guys can get a greater insight about this court case.
Hello, my name is Megan Raza, and I'm going to talk to you about the CDA and how it relates to the court case between Reno versus American Civil Liberties Union. So the CDA, the Communications Decency Act, was an attempt to protect minors from explicit material on the internet by criminalizing the knowing transmission of obscene or indecent messages to any recipient under 18, and also knowing the sending to a person under 18 or anything that in content depicts or describes in terms patiently offensive are measured by contemporary community standards, sexual or activities or organs. The CDA are unconstitutional and unenforceable except for the cases of obscenity or child pornography, because they abridge the freedom of speech protected by the First Amendment and are unsubstantially overbroad. The internet is entitled to a full protection given to the media like the print press. The special factors justifying government's regulations of broadcast media do not apply. Okay, now I'm going to send you over to Gabby so she can explain to you how this court case violates the First and Fifth Amendment.
Thanks for that amazing introduction, Megan. I'm Gabriela Cordero, and I'm here to talk to you guys about the First and Fifth Amendment and how it has to deal with this case. So as everyone knows, the First Amendment has to do with your basic freedoms: freedom of speech, freedom of press, freedom of religion, and so forth. The Fifth Amendment, although has to do with due process and double jeopardy, and although it doesn't talk about this much in that case, we all know that double jeopardy has to do with being tried again in court, which is illegal if it's for the same crime. So, regardless of whether the CDA is vague that it violates the Fifth Amendment, the many ambiguities concerning the scope of its coverage render it problematic for the First Amendment purposes. For instance, its use of the undefined terms incident and patently offensive will provoke uncertainty among speakers about how the two students relate to each other and just what they mean. The vagueness of such a content-based regulation, coupled with the increased deterrent effect as a criminal statute, raise special First Amendment concerns because of the obvious chilling effect on free speech. So because of the law that we're putting on and what people posted on the internet, we're basically taking away the freedom of speech, but we don't really know what the freedom of speech has to do in the First Amendment due to the internet. Contrary to the government's argument, the CDA is not saved from vagueness by the fact that it is patently offensive. Standard repeats the second part of the 3-pronged obscenity test set forth in the Miller versus California case. So the CDA then applies to sexual conduct, whereas the CDA extends also to excretory activities and organs of both sexual and excretory nature. So were these pictures wrong because of what they showed? Were they still allowed to have their freedom of speech even though they were showing indecent pictures? The CDA lacks the precision that the First Amendment requires when a statute regulates the content of speech. Although the government has an interest in protecting children from potentially harmful materials such as the leaked pictures on the internet, the CDA pursues that interest by suppressing a large amount of speech that adults have a constitutional right to send and receive these pictures. Now that you guys know all about the First and Fifth Amendment, I'm going to send you back to Melina Granda for the opinion of the court.
Thank you, Gabby. And so now I'm here to talk to you guys today about the opinion of the court. So, Justice John Paul Stevens wrote of the difference between internet communication and previous types of communication that the court had ruled on. In conclusion, he wrote, "We are persuaded that the CDA lacks the precision that the First Amendment requires when a statute regulates the content of speech. In order to deny minors access to potentially harmful speech, the CDA effectively suppresses a large amount of speech that adults have a constitutional right to receive and to address to one another. That burden on adult speech is unacceptable if less restrictive alternatives would be at least as effective in achieving the legitimate purpose that the statute was enacted to serve." And then he goes on to say, "It is true that we have repeatedly recognized that the governmental interest in protecting children from harmful material, but that interest does not justify an unnecessarily broad suppression of speech addressed to adults. As we have explained, the government may not reduce the adult population to only what is fit for children. The rest of the CDA, including the safe harbor provision protecting internet service providers from being liable for the words of others, was not affected by this decision and remains the law." So basically, through the use of chat rooms, any person with a phone line can become a town carrier with a voice that resonates farther than it could from any soapbox. Through this use of web pages, mail exploders, and news groups, the same individuals can become pamphleteers. So the court ruled in favor of the ACLU, the American Civil Liberties Union, because the CDA, they have no control over what happens on the internet. Like, for instance, when people sign in or have to say that they're 18 or over, there's no real way of verifying that they're actually 18 or over, or that they're adults. So minors can go on, but it's not on them necessarily because they don't know that.
So in conclusion, our group would have sided with the Supreme Court Justice in their ruling because you can't totally censor the internet without breaking the First Amendment's law. The court case itself doesn't completely say whether or not the internet has what it has to do with censorship and freedom of speech. So our court would rule the exact same way.